Hi you guys, it's your favorite consumer law advocate, Rebecca Simone. I'm back with a quick video to talk to you about debt collection as it pertains to lawyers. So, have you ever received a debt collection notice that was an attempt to collect a debt? It had the mini Miranda, this is an attempt to collect a debt from a debt collector. Any information will be used for that purpose, right? But it has a lawyer's information on it. This could also be a bankruptcy attorney. If you've had, first of all, if you've had that experience, put one in the chat for me. And second of all, keep watching this video because I'm going to give y'all some sauce. So, if a debt collector is sending you a dunning letter, because that's what that is, it's going to be a letter saying that, hey, we acquired your account, or they might say something like your account was assigned to us, or they might say that we're working on behalf of, quote-unquote, your original creditor. They're also going to say that they're going to give you the amount of the debt that you owe. They're going to give you some type of terms that you can repay it. They're also going to have a statement in this that says, if you dispute any part of this debt, you have 30 days, and there'll be a date on there that you have to dispute it, or they're going to continue to collect the debt. Now, the thing is, sometimes bankruptcy attorneys will get these accounts and they will proceed to sue you in small claims court because they know you already have acquiesced to the previous person that may have had it and not responded to them. So acquiescence basically means that you silently agree. So if you do not respond to a notice from a court, a summons to come to court for a debt collection, or if you come and you're not prepared, they can win a default judgment, which could result in a garnishment of your wages, which could result in a lien on property and things like that. So we don't want to get that far, right? So I want y'all to hear what I want y'all to hear these notes and discussions that I got from this Westlaw book. This is the United States Code annotated book, specifically on consumer credit and regulations. This is from the book that has 1691 through 1700 in it, because 1692 is FDCPA. Okay, so it basically talks about two pieces of case law. That one was where an attorney tried to use the 10th Amendment and said that a federal law governing how attorneys can collect on debt would basically be limiting their powers, and that power should be up to the state. This it is. Congress passed FDCPA pursuant to its enumerated power under the Commerce Clause, and thus the 10th Amendment did not apply to bar claims under the FDCPA based on statements made that in course of the state judicial proceedings. So basically in 2005, an attorney tried to take something to the Supreme Court saying that the federal government was trying to limit their powers, and that was supposed to be only that was supposed to be allotted to the state, basically. So the states are supposed to be able to govern their attorneys and anybody who has a license from their bar association. With that being said, this law limits how they, so as I was saying, this limits how they can collect on debt. So if they send you a notice, they have to be straightforward. When it comes down to how they conduct themselves when they're an attorney, yeah, the bar does regulate that, but then consumers have to complain to the bar for the bar to even know that they're out here committing fraud and violating different policies and being unethical, right? What's the chances of y'all doing that? Slim to none. Unless you me, but a lot of y'all not me. So with that being said, the average person doesn't know that an attorney has to abide by FDCPA as well. And if they misrepresent anything, if they use unfair and deceptive practices, if they do anything to misrepresent the character amount of the debt, or how much you are legally obligated to pay back, like misrepresenting how much they are charging you, misrepresenting who they are in a situation, because some of them will call themselves the current servicer or current creditor when you can't be a creditor. You could be a debt collector. You could be the person that was hired to collect on a debt, but you cannot tell me you are the current creditor and the original creditor was this person. Sometimes they tell you the original creditor was another third party. It's like, who actually gave me the credit that y'all trying to say I am indebted for? Make it make sense. With that being said, though, make sure you know who a person is in the transaction. A lot of times people pose as creditors when they're really a third party. A third party is anybody who does not have the exact same name as the person who you contracted with. Even if they're owned by the same parent company, whatever, they're technically a debt collector. Pursuant to 15 USC 1691 A6. 1692 A6, I'm sorry. I looked right at that and said the wrong thing. 15 USC 1692 A6 says that a debt collector is any person who uses instrumentalities of interstate commerce or the mills in the business, the principal purpose of which is the collection of debts, or who regularly collects or attempts to collect directly or indirectly debts owed or asserted to be owed to another. It goes on to say that the term includes any creditor who, in the process of collecting his own debt, uses another name other than his own, which will indicate that a third party is collecting or attempt to collect such debt. It goes on to say that any person who uses any instrumentalities of interstate commerce or the mails in any business, the principal purpose of which is to enforce security interests. So all of those people, the people who are collecting on your mortgages, people collecting on your student loans, people who are collecting on payday loans, all of that stuff, these people are debt collectors technically. So if they're misrepresenting themselves, this is one violation. Go look it up yourself. 15 USC 1692 A6.